There are 6 forms that every American homeowner over the age of 60 has to file, but most never do. And the day they die, those 6 forms cost their children the house. I am going to walk you through every single one of them today. The exact dollar amount each one saves, the order to file them in, and the one form on this list that 9 out of 10 seniors never even hear about until it is already too late to do anything about it. Here is what most people do not realize. The legal system in this country was not designed to protect your family. It was designed to generate revenue for state courts, probate attorneys, and the legal industry. Every single year, hundreds of thousands of American families lose tens of thousands of dollars because nobody told them about the 6 documents that would have stopped it. These families worked their entire lives to pay off a home. They raised children in that home. They planned to pass that home down to the next generation. And then the system got involved. A court took over. Attorneys started billing. And the family watched everything they built get eaten up in fees and legal costs before a single dollar ever reached their children. The worst part is that most of these documents cost less than $200 to file. Some of them are completely free. But if nobody tells you they exist, the system takes everything. That is what this video is here to fix. We are going to go through all 6. I will give you the exact dollar amounts. I will tell you the critical window for each one. And I will end with the 5 steps you need to take this week to get protected. Stay with me, because the 5th form on this list is the one almost nobody knows about, and it is the one that changes everything. Before we get into the forms, let me explain why this keeps happening. Most seniors assume that having a will is enough. It is not. A will still goes through probate court. A will still gets supervised by a judge. A will still requires attorneys, filing fees, and time. Probate court costs between 3 and 7% of everything you own. On a $300,000 home, that is between $9,000 and $21,000 your children have to pay before they can even touch the deed. That money does not go to your family. It goes to the system. It goes to the court. It goes to the attorneys. And your family gets whatever is left. The 6 forms in this video are the ones that let you bypass probate completely. They protect your home from Medicaid recovery. They keep the courts out of your family's business. And they cost a fraction of what the alternative costs if you do not have them. The first form is the transfer on death deed. This is also called a beneficiary deed in some states. It is a single piece of paper that says who gets your house when you die. No court, no judge, no attorney reviewing anything. Your child walks to the county recorder's office with a copy of the death certificate and a copy of this deed, and the house transfers to their name. That is it. Without this deed, your house goes into probate. Your family waits 6 months to 18 months while a court supervises the process. They pay between $9,000 and $21,000 in fees on a $300,000 home. With this deed, the cost is somewhere between $50 and $200 to prepare and record. The savings are real. The math is simple. And this deed is currently available in 31 states, including California, Texas, Nevada, Arizona, Colorado, Illinois, and Missouri. If your state is on that list, this is one of the first documents you need to file. The critical window is that it has to be signed while you are still mentally competent. The moment a doctor questions your capacity, you cannot sign it. The moment you are in a hospital with a serious condition, it may be too late. The time to file this document is right now, today, while nothing has happened yet. The second form is the Ladybird deed. This one is also called an enhanced life estate deed. It is available in only 5 states right now, which means if you are in one of those states, you have access to something most of the country does not. The 5 states are Florida, Michigan, Texas, Vermont, and West Virginia. Here is why this deed is different from the transfer on death deed. With a regular life estate deed, if you add your child's name to the deed, you lose control of the house. You cannot sell it without their permission. You cannot refinance it without their signature. The Ladybird deed solves that problem. You keep full control of your home during your lifetime. You can sell it, refinance it, change your mind about who gets it, and do whatever you want with it. But when you die, it passes directly to the person you named without going through probate court. And here's the part the government does not advertise. In Florida and the other states where this deed is recognized, a Ladybird deed also protects your home from Medicaid estate recovery. That means even if Medicaid paid for your nursing home care, they cannot force the sale of your home after you die to get that money back. Without this deed, the state can place a claim against your estate after you die and recover every dollar they spent on your care. On a nursing home stay that costs $10,000 a month, that adds up very fast. The Ladybird deed costs between $200 and $500 to have an attorney draft and record. Without it, Medicaid recovery can cost your family the entire value of the home. If you live in one of those 5 states, call an elder law attorney this week and ask specifically about the Ladybird deed. The third form is the Revocable Living Trust. This is the one most people have heard of, but most people never actually set up. A revocable living trust works like a container. You set it up, you put your house inside it, and you control everything inside it for the rest of your life. When you die, the The trust handles the distribution of everything inside it without going through probate court at all. Your children do not have to wait. A judge does not get involved. Attorneys do not need to supervise the process. The assets in the trust pass directly and privately to the people you named. Now here is the number most people do not realize. Probate is public. Every document filed in probate court is a public record. Anyone can look up what you owned, who you left it to, and what the estate was worth. A trust is private. None of that information is public. For families who value privacy or who have complicated situations, this matters enormously. A revocable living trust costs between $1,000 and $3,000 to set up properly with an estate attorney. That sounds like a lot until you compare it to the $12,000 to $28,000 in probate fees a $400,000 estate would cost without it. There is a critical mistake most families make with trusts. They set up the trust and they never put the house into it. This is called an unfunded trust. If the house is still in your name and not in the name of the trust when you die, it still goes through probate. The house has to be retitled into the name of the trust while you are alive. Ask your attorney to help you do this at the same time you set up the trust. Do not set up a trust and forget to fund it. That mistake erases every protection this document offers. The fourth form is the durable power of attorney. This is not a document about death. This is a document about what happens if you are still alive, but you cannot make decisions for yourself. A stroke, a serious accident, a diagnosis that affects your cognition, anything that leaves you alive but unable to manage your own affairs. Without a durable power of attorney, your family cannot pay your bills. They cannot manage your bank accounts. They cannot make decisions about your care or your property. They have to go to court and ask a judge to appoint someone as your guardian or conservator. That process costs between $3,000 and $10,000 in legal fees. It takes months, and the judge gets to decide who is in charge of your affairs. It may not be the person you would have chosen. With a durable power of attorney, you name the person you trust to manage your affairs if something happens to you. That person can act immediately. No court, no judge, no months of waiting while your bills go unpaid. The cost of drafting a durable power of attorney is between $100 and $300. The cost of not having one is between $3,000 and $10,000, plus the emotional cost of watching a courtroom decide who gets to manage your life. This document has to be signed while you are still mentally competent. The moment a doctor questions your capacity, you cannot execute this document anymore. That window is not open forever, and once it closes, the courtroom is the only path left. Before we get to form number 5, I want to remind you of something. The 5th form is the one I told you almost nobody knows about. This is the one that 9 out of 10 seniors never file. If you only file one document after watching this video, let it be this one. Stay with me. The 5th form is the Medicaid Asset Protection Trust. Most people have never heard of this document by name, and most of the people who have heard of it do not understand how it works or why it matters. Here is the situation it solves. Medicaid has a rule called the 5-year look-back period. If you ever need long-term care in a nursing facility, Medicaid will pay for it, but only after you spend down almost everything you own first. And before they start covering you, they look back 5 years at every asset you transferred or gave away. If you gave your house to your children 2 years before you applied for Medicaid, that gift counts against you. The state calculates a penalty period based on the value of the gift. During that penalty period, Medicaid does not cover your care even though you have nothing left to pay for it yourself. A Medicaid Asset Protection Trust solves this by moving your assets out of your name and into an irrevocable trust more than 5 years before you ever need nursing home care. Once the 5-year clock runs, those assets are protected. Medicaid cannot count them when calculating your eligibility. And when you die, those assets pass to your beneficiaries without going through probate and without being subject to Medicaid estate recovery. The cost of setting up a Medicaid Asset Protection Trust is between $2,000 and $5,000 depending on your state and your attorney. The cost of not having one is the entire value of your home, liquidated to pay for nursing care that Medicaid would otherwise cover. Nursing home care costs between $8,000 and $15,000 per month. A 2-year stay costs between $192,000 and $360,000. Without this trust in place, before that window closes, that entire cost comes out of the assets you plan to leave to your family. The critical window here is the 5-year look-back. The trust has to be established and funded at least 5 years before you apply for Medicaid. If you wait until you are already sick, until you are already in a facility, until the need is already urgent, it is too late to protect anything. This is the document that requires the most lead time. This is the document most seniors put off because they feel fine right now. And this is the document that, more than any other on this list, costs families everything when it is not in place. The 6th form is the homestead exemption. This is the one that is costing you money right now, today. Every single month you do not have it. Every other form on this list protects you from future costs. This one reduces what you are paying right now. Most states offer a homestead exemption to homeowners who live in their primary residence. When you file a homestead exemption with your county, a portion of your home's assessed value is removed from the taxable amount. In some states, the exemption is $25,000. In Texas, the exemption is $100,000. In Florida, it can be up to $50,000 or more. On an average tax rate, that homestead exemption saves you between $500 and $3,000 every single year. Over 20 years, that is between $10,000 and $60,000 that stays in your pocket. Here is the part that makes people angry. Counties do not send you a letter telling you about this. They do not call you, they do not remind you to file. If you do not know it exists and file it yourself, they just keep collecting the full amount and never tell you that you were entitled to a reduction. Filing a homestead exemption is usually free. You go to your county assessor's website or office, fill out a short form, and submit it with proof that you live in the home. Most counties let you file online, and in many counties, once you file, it renews automatically every year. The mistake most people make is assuming they already have it filed. Go look it up right now. Search your county name plus homestead exemption and check whether your home shows the exemption on your property tax record. If it is not showing, you have been overpaying. File it immediately. In some states, seniors over a certain age qualify for an additional senior homestead exemption on top of the standard one. Ask your county assessor whether you qualify. Now let me give you the 5 steps to take this week. Not next month, not after the holidays, this week. Because every window on every document we just covered closes the moment something happens to you. Step 1 is to find your house deed. Go to your filing cabinet, your lockbox, or your county recorder's website and locate the deed to your home. You need to know exactly how the house is titled right now. Is it in your name only? Is it in your name and your spouse's name? Is it already in a trust? You cannot protect what you do not know how it is currently held. Step 2 is to write down which of the 6 documents you already have. Transfer on death deed. Ladybird deed if you are in one of those 5 states. Revocable living trust, durable power of attorney, Medicaid asset protection trust, homestead exemption. Write them down. Put a check next to the ones you have and a circle next to the ones you are missing. That list is your action plan. Step 3 is to research any document you do not have. Take each document name you circled and search that name plus your state. Read the first 3 results. Understand whether your state offers that specific protection and what the filing requirements are. Some documents are state-specific. Some require an attorney to draft. Some you can research and then confirm in a consultation. Get familiar with what each one requires before you call an attorney so you can use that time efficiently. Step 4 is to call an elder law attorney in your county and ask for a 1-hour consultation specifically about home protection documents. Tell them which documents you already have and which ones you are missing. Ask about the Medicaid look-back period and whether a Medicaid asset protection trust makes sense for your situation. Ask about the specific protections available in your state. The cost of this consultation will be between $200 and $400. That is the best $200 to $400 you will ever spend on protecting your home. Step 5 is to act. Do not walk out of that consultation and put the paperwork on your kitchen counter for 6 months. Get the documents drafted. Get them signed. Get them recorded. Every document on this list has a window, and every one of those windows closes the moment something happens to you. The moment you are in a hospital. The moment a doctor questions your capacity. The moment a stroke or an accident changes your situation. Once that moment arrives, none of these forms can be executed anymore. The only path left at that point is the courtroom. And the courtroom is exactly where the fees start and the family's money starts disappearing. Let me recap what we covered today because these are the 6 forms that protect everything your family worked for. The transfer on death deed transfers your home directly to your children without probate, saving between $9,000 and $21,000 in fees, and it is available in 31 states. The Ladybird deed gives you full control of your home during your lifetime while protecting it from Medicaid estate recovery after your death, and it is currently available in 5 states. The Revocable Living Trust keeps your estate out of probate court, keeps the distribution of your assets private, and protects your family from the $12,000 to $28,000 in probate fees on a mid-size estate. The Durable Power of Attorney names the person who manages your affairs if you cannot, saving your family between $3,000 and $10,000 in guardianship court costs. The Medicaid Asset Protection Trust protects the home and other assets from being consumed by nursing home costs and Medicaid recovery, and it requires 5 years of lead time that most families do not give it. And the homestead exemption reduces your property taxes right now and saves you between $500 and $3,000 every single year you have it filed. The best thing you can do after watching this video is send it to one family you love who has aging parents. That one share might save them $20,000 or more. Most of these forms cost less than $200 to file. Some are completely free. But if nobody tells them about it, the system takes everything they worked for. You now know about all 6. So does everyone you share this with. If you are not subscribed yet, do that right now and hit the bell notification. Estate planning rules change every year. When they change, this channel breaks down exactly what those changes mean for your home, your family, and your situation. That is what this channel is here for. Go find your house deed today. Write down which of the 6 documents you already have and which ones you are missing. Search the name of any document you do not have, plus your state name. Call an elder law attorney and ask for a 1-hour consultation about home protection documents. The cost is between $200 and $400. Then file the ones you are missing. That is how you protect your family's home. Do not put this off until next year. Every window on every document we talked about today closes the moment something happens to you. Once you are in the hospital, once the court gets involved, once a doctor questions your capacity, none of these forms can help you anymore. The time to act is right now.